Stanislav, you promised to give us the update about the conference in Seoul in South Korea that you visited and to give us all the news and juicy updates. All right, guys, I'm gonna do this today and of course sticking to the promise. And also you will learn today how to get the free evaluation on the visas that will give you the best chance to come to the US. Let's go! Hello, my dear friends, I'm Stanislav Shamayev, a licensed business immigration and corporate attorney in Miami, Florida. Today, we're discussing the juicy updates from Seoul, the capital of South Korea, which I visited for the purpose of immigration conference organized by Aila, Asia chapter, and to my surprise, guys, there was a bunch of good news or a bunch of refreshing things that you already know, but it's always good to hear that they still exist. Let's start generally, and the first thing that for those of you who are in the embassy waiting for your approvals or denials of the issuance of your visas, and if that time is above 6 months and nothing happens, use the Legal Net. Legal Net is the service which you can use to contact the embassy where your case is getting the dust and get some type of result. If you used Legal Net and nothing happened, you may be looking at mandamus lawsuit in a federal court in the US to push the embassy to do things that they have to do. But before filing the mandamus, you have to first get the FOIA. It's Freedom of Information Act, and you can file FOIA to any federal agency to get the information from those agencies. So what are you going to ask about in your FOIA when you file it before the mandamus is the exact processing dates of that particular embassy for your particular visa. Why? Because if that embassy has a longer processing time, maybe beyond a year or whatever, and you go for mandamus immediately, it's going to be dismissed. Okay, and they may require you to pay the attorney's fees. So you wouldn't want that. We want to know for sure that they overstepped the authority by not giving you the visa within the time frame that they have on average for this type of visa. Also, number 3, our colleagues share the knowledge which embassies in the world are willing to take the clients from third countries, meaning not from those countries, right? And that applies a lot to India-born clients, okay? But also other people as well, right? So what are those countries? Mexico, Bahamas, and Bermudas. Those US embassies are willing to take your cases from other countries. Of course, you have to contact them first to find out if that's good for your case. In my company, I have the Department of Communication with the embassies, and on case-by-case analysis, we find the best embassies for you guys. Number 4, the new requirement to register in the US. And of course, they want illegal immigrants to register. Who cares? Nobody's gonna do this. But if you have children who were below 14 years old when you guys got issuance of your visas, regardless, immigrant, non-immigrant, and your kids did not get fingerprints. So 2 things, kid below 14 at the time of the issuance of the visa, and the kid was not fingerprinted because some embassies do. Then within 30 days of that kid becoming 14 years old kid, you have to register him with USCIS, and that's done through the field office. Okay, it's easy to Google that and find the way to do that. Guys, very serious. It may not sound like it, but it could be the reason for a lot of bad things, not only for the kid, but for the parents as well. So make sure that you do this. Number 5, the colleagues share the knowledge about L1 visa And I do L1 visas as well, intra-company transfer, when there's a company outside, there's a company in the US, and a manager or the executive or a specialized knowledge person is being transferred to the US company. One of the hardest visas in the galaxy, to be honest. We still getting approvals on those. I didn't see any change, but I don't have as many cases that some of my colleagues do, because my main focus are talent visas, national interest waiver. Maybe we get like 30 L1s a year, okay? Which some of you may think, oh my God, this is a lot. That may be a lot unless you know that we do like 300 talent visas, right? Or even more. So comparing to other things, this is a small number for my practice. And same as us, our colleagues are of the opinion that L1 didn't get any hit from Trump administration, so things are normal. If you guys fall within that visa, we will be happy to help you. Number 6, interesting fact, guys. The colleagues share the knowledge about O1 visa. When you use your own company as your own employer, you do not have to get paid in that company through W2. You may get royalties or even sometimes dividends. I kind of disagree with that. And it's not that I don't think it's not gonna work. It could work, but if you get that officer who doesn't know the details, the specifics of, it may be a disaster. Okay, because this type of things could turn the tables, and that could be really bad for your case. So my suggestion, get yourself the lowest market salary on W2 through your own company or O1, and get the rest as distribution. And before I said dividends, now I'm saying distribution. Technically the same thing, but for the tax purposes, you better use the term distribution, all right? And why? Well, because you're not being taxed on distribution for Medicaid and Social Security, which can save you like 16% on the taxes on those amounts, which is a lot. That's what I think is the best, especially if you have S Corp in the US. LLC may be a little bit different approach, but still, I think W2 is just a classic way. Although I agree that there may be technically a lawful way to do it differently. And a few more things that colleagues mentioned about the criteria for EB1A. I knew most of them or been using them long time ago, but something was told that I was like, okay, this is good. So I'm not gonna give you all because some of them are repetitive, but if you are a member of accelerator or incubator, and those are the famous ones, and which ones are the famous? Well, the ones that have press coverage and some recognition in the industry, or maybe famous people organize those organizations, they could be a membership in a professional association. And if you got venture or angel investments through those organizations or outside of them, those could be qualified as awards. So we've been doing this before, and Trump is less perceptive to those alternative ways to prove the criteria. But the case law and prior administrations were of the different opinion, so still some officers will accept those evidence in lieu of regular and meet those criteria. And before I share the last update with you guys, and again, the reasonably interesting update, because there's a bunch of smaller ones, we can talk about it on my Thursday streams on YouTube. But before I get to the last one, which is pretty good, guys, get the free evaluation for talent visas, national interest waiver, or business visas, because those visas are the best either to get a green card or ability to come and work here in the US. And those are the visas that are specialized in. It's really easy to get the free evaluation. The link is below this video. Click on it. Open the website, find the link for talent visas or business visas, fill one or all of them out, and give me 2 days to analyze and break down your case. I'll come back to you with analysis. Look for the word potential. If you have the potential in your case, that means that I can work on your case with my team for the next 6 months and improve it to 90 to 99 chance of approval rate and get you here in the US. So if you see that potential word come to the complex immigration planning, the service where in 2 phases I will build and create a winning strategy for your case, which then becomes a cornerstone for your future case working with my team. So get that free evaluation out of the way and look for the word potential. And last but not least, the colleagues mentioned, and I just want to comment on that the expert opinion articles in famous journals like Forbes or TechCrunch could be used in the criterion of the academic scholarly articles. And guys, I disagree. I disagree with this opinion. Maybe they could be used as supplemental articles, but from my experience, for the purpose of EB1A, you have to use the academic scholarly articles, and we have the means to help you to get those done within the 6 months. Where you could use those expert opinions, probably in O1 visa or in a subjective criterion. I would agree to use those articles in the core petition itself if it's not only in Forbes or TechCrunch, but also the style of those articles is academic, like the citations, the references, the footnotes, the diagrams, the charts, the statistics, the numbers. It must have the science of the academic writing. Okay, it just cannot be your professional opinion on something which is still great for the case. In Forbes, of course, we'll take it and we're going to use it, but it's not going to satisfy the academic articles criterion, all right? Especially for EB1A. I've seen it, we've done it, we tried, and of course we can fight, we can try to sue them. Nobody wants to deal with this. Neither you, nor me, nor the officers. So let's give them what they want, and they want the academic articles, all right? And give me 4 for the EB1A. All right, guys, get that free evaluation right now. Okay, don't wait for Independence Day. You're gonna waste your time. If you get that word potential, come to the complex immigration planning and then start your case with my corporation to get you above 90% chance of approval of your petition, where in the industry that is 45%. Smash that like button, comment, ask me a question, subscribe to my YouTube channel. I also have other social media with exclusive content on each, so follow me on Telegram, Instagram, Facebook, X, and wherever you wish, where I have the account. My name is Stanislav Shamayev. I'm a lawyer of the future. Your future begins here. Good luck.